start. As it appears, the High Court has taken exception to the fact that the application was moved when the second judge was allotted the roster to deal with the application under Section 438 CRPC. To appreciate the analysis made by the High Court, we have bestowed our annexes consideration and perused the order impunged. As far as the distinction drawn by the High Court passed in a perverse manner, excluding the relevant matters and considering the extraneous matters which deserves to be lancinated in exercise of supervisory jurisdiction to nullify the same and the other, which is fundamentally and absolutely situation based for cancelling the order of bail because of violation of the terms and conditions of the order granting bail and other supervising circumstances. However, the said situation or circumstances does not arise in the case at hand. In that context, this court held that long-standing convention and judicial discipline requires bail application to be placed before the learned judge who had passed earlier orders. On a perusal of the aforesaid authorities, it is clear to us that the learned judge who has declined to entertain the prayer for grant of a bail, if available, should hear a second bail application or the successive bail applications. It is in consonance with the principle of judicial decorum, discipline, and propriety. Needless to say, unless such principle is adhered to, there is enormous possibility of forum shopping which has no sanction in law and definitely has no sensitivity. These appeals have been preferred against the orders passed by the division bench of the Punjab and Haryana High Court at Chandigarh. The appellants in special leave petition of 2012 are the Chandigarh administration and the Government Medical College and Hospital Chandigarh. The appellant has filed a special leave petition with the permission of this court, who was not a party either before the single judge or before the division bench of the Punjab and Haryana High Court. Leave to file special leave petition was granted in considering the grievances expressed by the said appellant, contending that in the event of the imposed orders of the division bans being implemented, her chance of getting admission to the course of MBBS for the academic year 2014-15 under the non-resident Indian category would be imposed. The present imposed orders of the division bans came to be passed. This appeal was made at the instance of the contesting respondent in both the civil appeals, who was really aggravated of a clause in the prospectus issued by the appellants, which according to her was not valid. According to the contesting respondent, she being a Canadian citizen is an NRI that therefore she was entitled to seek admission to the MBBS course in the NRI category quota, but yet the definition of NRI as specified in the prospectus issued by the Chandigarh administration and the Government Medical College, Chandigarh for the academic year 2012-13 would denude her of such status, and therefore it was liable to be struck down. The contesting respondent claimed that her grandfather retired as an undersecretary in the year 1984, that when he was in the services of the state of Chandigarh, he resided in a government house from 1964 to 1983 and shifted to another government accommodation provided by the Chandigarh administration from 1983 to 84. That third set of government accommodation was provided by the government of India to the father of the contesting respondent, which was occupied till December 2003, and that their father, after her father started living in the house of her grandfather in Mohali. The contesting respondent claimed that she passed as a regular student from Mohali, that the prescription contained in paragraph 2 of the prospectus providing for eligibility and merit for NRI seats for MBBS course, stipulating that the grandparents or parents of the candidates should be resident of Chandigarh for a minimum period of 5 years at any time since the origin of Chandigarh, and should have immovable property in her name in Chandigarh for the last at least 5 years, and a certificate to that effect issued by DC come state officer or municipal corporation of Chandigarh. It was an that come state officer municipal Chandigarh that footing that a challenge came to the made by the contesting respondent in the High Court in CWP number 1423 of 2011. The land single judge by order held that the impunged clause was totally impracticable, illegal, illogical, and declared as such. However, the land single judge went further into the question as to whether the contesting respondent can be granted admission. Stop.